Welcome to day 2 of Privacy Week. It is my pleasure today to have Blair Scotland from Dundas Street Employment Lawyers join me. And today we're going to be talking about privacy in relation to whistleblowing and the Protected Disclosures Act. And what I'll firstly do is hand over to Blair, and if you'd like to give yourself an introduction.
Good afternoon, everybody. I see some familiar names of people who've joined us, so I better watch what I say and who I talk about in this. Look, thanks for having me along, Campbell. Look, I've had an interest in privacy probably as long as I've been an employment lawyer, and that's very much the focus of what I take. I've been practicing in employment for 25 plus years, something like that. My focus is very much on representing employer clients, and a big part of what we do does have an important privacy focus, does have a focus in terms of protected disclosures as well, which is another area I know, Campbell, you have a particular interest in. So yeah, my perspective is very much from that position of giving advice on employment law issues and how privacy interacts with that, both in terms of dealing with things like personal grievances and restructures and redundancies and all that sort of stuff through the disciplinary processes, but also more broadly, thinking about employee privacy. What do we need to do? What do we need to have in place? So yeah, that probably gives you a bit of a flavour of where I come from and what my particular interests are in these fields.
Thanks for that, Blair. And being privacy this week, in celebration of that, what does privacy mean to you in your role as an employment lawyer who specialises in privacy and whistleblowing?
Yeah, well, look, I think it's a great opportunity to think about privacy as an issue. I know with some of the questions that you're going to ask me, I mean, my observation is that privacy is often overlooked or maybe underappreciated in the concept of employer-employee relationships. It never ceases to surprise me that there are still sort of from people who are experienced and who know a lot of things about employment law and related aspects, but there's often we overlook or forget about privacy aspects. So I think Privacy Week's a good opportunity for us to think about privacy, to think about, well, have we got the right things in place here? Are we paying privacy the appropriate attention it needs within our particular workplace? Are we following best practice? Do we have everything we need there? Again, look, I'd be honest and say it's great to have an audience here who are interested, but unfortunately, not every organisation we deal with necessarily has privacy at the forefront of its mind, and that's sometimes it's often it takes a large adverse event in terms of a breach of privacy or something going wrong before people actually focus their minds on the issue. So I think if at all possible, if Privacy Week can get us to focus on making sure that we're doing things right, following best practice, that's a great thing that the week provides for people.
Indeed. And we were just talking offline before we joined the call, and my belief is Privacy Week will become more and more prevalent in the years to come. But I just wanted to touch on sometimes legislation takes a while to come through, and a number of years ago there was a sniff that the Privacy Act was going to be updated, and indeed it was in 2020, and then the Protected Disclosures Act was likely to be updated, and indeed that was in 2022. So just in the last couple of years, we've had two major bits of legislation in New Zealand that obviously require organisations to do things a little bit better than what they had done before. There were updates to each of them. I have certainly seen over the last 5 years a big increase in concerns around breaches. What would be your thoughts on the information that organisations obtain in the event of a whistleblowing or protected disclosure. So from the disclosure into the organisation, and then passing it through to someone like yourself as well. What are the steps organisations need to think at from the outset?
Yeah, so I mean, it's been interesting. Those two pieces of legislation you mentioned, they see the changes to them seem to have incredibly long gestation periods to actually get there, and that's I think it's been interesting just looking at the changes we've seen. We've seen at our end a bit of a flurry of interest in getting things up to date, more so from the protected disclosures end than the privacy end, because in a lot of instances, for most employers, Privacy Act changes haven't been, completely radical. It's sort of building on existing concepts, but some of the protected disclosure stuff has been interesting. Some interesting changes for people to think about. So, in terms of your question about the things to be thinking about, how the information sort of flow works, I think a starting point that I would bear in mind is that most organisations we deal with, protected disclosures, people whistleblowing, is the exception for most organisations rather than the norm. So it's something that seems to, for a lot of organisations, happen once in a blue moon if it happens at all. And of course, that leads to a bit of from what I see, a bit of a flurry of excitement of like, oh, good grief, we've got this thing. It's come here. Hold on, what do we do with this? What are our obligations, and what do we do? What is the process that we follow? What are our steps that we have to take? What do we have to let people know? What protections do we have to put in place? Because in terms of protected disclosures, the obligation to keep the discloser's identity confidential, except in particular limited circumstances, applies, and arguably I think has more teeth in the new legislation. So I think one of the biggest issues is A, do you have an up-to-date process in place? And B, do you have people on board who know what to do if these sorts of aspects come up? And having someone who knows what the law requires, knows what your internal process is, and will follow that is kind of key to managing that flow of information, because it helps you determine, well, okay, we've got what purports to be a protected disclosure. That may not actually say that it is one, but it still may be a protected disclosure. Who's the person to assess that? Are they the right person? Who within the organisation could or should we be letting know in terms of that? There's there's tests in terms of, well, when might we just have to disclose the person who's made the protected disclosure's identity to others, in terms of natural justice, in terms of letting other appropriate authority know. So there's quite a lot of work that goes into it when you get a protected disclosure, and my observation is, no two seem alike. They always have their own different sort of issues, different considerations. And I think, the key bit of advice I'd give to people is make sure you have an up-to-date policy and process around this, that people know what it is, but that you have a dedicated person, much like having a privacy officer, which is, another, and they may well be the same person, seems to often be the way. But having a person who knows what to do, and can liaise and manage that process, particularly around protecting people's personal information because of the confidentiality of obligations. Yeah, that would be my observation around that aspect.
No, that's great. I was thinking about something you said part of the way through there about the two different types, but I just wanted to touch on as well the difference between protected disclosure and whistleblower, and what it means to an organisation and the need to keep people's identity confidential. So I often get asked, can we only take whistleblowing disclosures if they fit under the protected disclosures regime? And of course, the answer is no. You set what your policy needs to be, but of course, you don't want it to be a fairly low level type HR issue, because it's supposed to be, whistleblowing is supposed to be about serious conduct and serious harm. Thinking about a situation where an organisation is trying to encourage their employees to speak up about certain things, and it's very, very difficult for that employee to keep who they are and what's happening confidential, because by telling who the supervisor is, it's going to give them away. What are some of the mechanisms that you would recommend, understanding this isn't formal legal advice, it's you and I having a chat during Privacy Week, but, what are some of the things people should think about to try and protect the identity of people? And you've got to tell them in advance, of course, as well. You've got to say, please call this number, but don't give us too much revealing information.
Yeah, I mean, look, it's difficult to give a one size fits all answer, because I mean, you as you mentioned, there's kind of two different processes almost, isn't there? There's your protected disclosure of serious wrongdoing, which has statutory protections, and then there's everything else which does not necessarily have statutory protections associated with it. And when you're building a process, thinking about, well, how can we, and even if we can protect people's information, where there are those statutory obligations, because as you say, if I I might make a protected disclosure, but by the very nature of the information I am disclosing, it may be inherently obvious who it's coming from. That's unfortunately part and parcel sometimes of making a protected disclosure, and that's one of the, as you mentioned, one of the key things you need to be upfront with people in any policy or process around these sort of aspects. Likewise, anonymous protected disclosures, the legislative framework doesn't really recognise that as a concept. There's actually requirements in the legislation to consult with the disclosure in respect of certain actions in the process, and to report back to the disclosure. If you don't know who the disclosure is and don't know how to get in contact with them, then arguably that sort of information falls outside of the framework of a protected disclosure. So it is each situation is difficult. What I say as a general rule of thumb is, if the protected disclosure is able, if you're able to put the question is, generally speaking, can you put that information, the allegation, to, if you're investigating it, that is, can you put it to the person against whom the claim of serious wrongdoing has been made, without giving the information about who has given it? In other words, can they, let's say I'm accusing Campbell of stealing and ripping off the company credit card and all sorts of other outrageous things. Do I need to give Campbell the name of the person who's told me this, or can I just go through the records, dig out the credit card receipts, dig out the transactions, and say, here is the information here? Now, the question is, does Campbell need the name of the person in order to be able to respond to the allegations? I'd argue no. He doesn't need that information, and therefore I can protect the discloser's identity as the Protected Disclosures Act. Other things like, perhaps, say, serious bullying or sexual harassment that amounts to serious wrongdoing, unfortunately, I'm probably not going to be able to withhold the identity of the disclosure. But again, the legislation provides a mechanism for how I need to go about doing that, which is hence the importance of having a good policy that sets this up from the outset, to make sure that people's expectations of what you can do, what you can withhold, and what you can't withhold are clear, but also having someone who's managing the process who understands exactly how this sort of stuff works, and how to manage those difficult those difficult trade-offs that have to occur when it comes to disclosing people's identity or not, as the case may be. So, I mean, it's interesting. There's only been really one case that's been to the employment court about that sort of identity, and it was a case that we were involved in, and yeah, it very much sort of touches on that point. It's that exercise of looking at, well, do you actually need the threshold of, do you really need to disclose the person's identity when you're dealing with the protected disclosure? If it's not the case, then you don't, there's no obligation. You should protect their confidentiality, and the provisions in the Employment Relations Act need to be read alongside the protected disclosures protection of whistleblowers legislation too. So yeah, there's a bit to think about, but you can do a lot of work in advance to get yourself set up in the best possible place.
And thanks for that, Blair. That was all very useful information, and I was thinking about a few things through that. But one thing I think about when I think about policing, which my family background has been in, the very mention of blowing the whistle, it can come from sports, it can come from the police officer blowing the whistle as well, but certainly policing has been pretty successful over the years when they've been able to obtain confidential information from informants. And of course, you're never going to put that informant up in the court to give evidence. It'll be the role of the police to take that information and go and revalidate it. And indeed, on a number of the cases I worked on in the police, that's exactly what we did. And if we couldn't revalidate it, well then, there's not a lot of evidence to go from. What I wanted to also bring in was, I have noticed since the new Protected Disclosures Act was updated last year, a lot of organisations want to update their policy, or bring into the year 2022 what they should be following, but for whatever reason they actually find it quite difficult excuse me, to take those actions and do them relatively quickly. How hard actually is it for an organisation to go from 0 to 100%?
It's not that difficult in actual fact, because so a lot of the core principles haven't fundamentally changed. It's really just my advice is to build a bit more process around how you do things, and build in some of the new requirements and new changes into your policy. So I've done a few for a few Crown entities and government departments. It's not actually a big deal, and a couple of big private sector clients as well. It's not a major issue. Interestingly, one of the things that a couple of clients have struggled with, and this has actually been at a governance level, is of course the ability for a disclosure to just go outside of the organisation in the first instance to what's called an appropriate authority, which is one of a number of particular, generally governmental agencies, but not wholly. That's actually been the biggest sticking point, saying, oh, what do you mean we should be telling these people they don't have to come to us in the first instance? They can go to an appropriate authority. And of course the response is, well, that's what Parliament says they can do. Unless you want to get Parliament to change that, we should update it, processes. But yeah, to answer your question, it's not actually a big deal. It doesn't take a whole lot of work to do these things. It's actually, there seems to be the work is actually getting more governance sort of people on board with the concepts and changes, and ensuring that you've got the right person available as the guardian, the recipient of the process. Maybe those are two separate, different roles. One has a more of a governance role, one has a more of an operational role in terms of managing protected disclosures. But yeah, I think it's a good thing. Where I have found it tricky, where it is trickier, is, as you were talking about before, having a one size fits all speaking up policy that covers both protected disclosures, which are a specific subset, and then another process for broader concerns. That becomes more difficult, because depending on the nature of the concern being raised, I want to raise a concern about the way I'm being treated by my manager. Well, that's possibly that might be the bullying sort of route. Well, we have a policy on that. Well, I've been propositioned by, this colleague, and it's, having a detrimental effect on me. Well, that might be our sexual harassment policy. That's better dealt with under there. So yeah, it can get tricky if you try and draft a policy that's designed to be all things for all people. But that's just a practical observation I've had in recent times.
And one other aspect, perhaps if I can get you to touch on, is if the disclosure is about the person who the disclosure should be going to, who would that other party be?
Yeah, look, and that thinking about that within an organisation is key. So it's like, if the person I want to, the legislation provides for a default, and that you can go to the chief executive in the first instance, in any event. You don't have to go to the employer's dedicated person, so you can go to the chief executive. But I think building in sort of a variety of checks is an important thing. So it might be, let's say the first port of call might be your general counsel as the subject matter expert, and if the complainant doesn't like that, or the complaint's about the general counsel, the chief executive could be next. And then if the complaint's about the chief executive, the complaint should be to I don't know, the chair of the board
chair.
potentially, or the chair of a particular committee at that board level. I've seen that done. I can see that to be done quite effectively. In other instances, in the public sector, for example, there is no one above the chief executive per se. It's you're into the Public Service Commission. You're directing people towards the Office of the Ombudsman, for example. So thinking that through, what are my alternative routes to give people to raise issues so that they feel complete. Because I'm like you, Campbell. I think it's a positive thing for people to be able to raise concerns. Whether those concerns turn out to be exactly what people think they are, well, it's better that we know in advance than find out in the media or through other ways. These are good things to be looked into.
Thanks, Blair. I'm going to finish with one last question, which is not something that you and I have discussed yet, but that is just how social media and we see so many people being prepared to type things in social media about their companies and their customers. And there was one that was quite open yesterday in the media as well. It got a lot of attention. What would be your thoughts on not necessarily organisations telling their staff and to not do that, but if making sure that if they've got a valid grievance, to pass it through the right channels, and then also the very first step organisations should do to sort of validate that what this information the person's disclosing about is likely to be correct.
Yeah, well, there's a couple of sorts of things there. Look, I think firstly I'd say have a good social media policy in place. If you don't have an IT and social media policy that covers what's appropriate and what's not, and you don't have that widely sort of available to people, that's something to work on. I also think being clear to people that if they have concerns, what the appropriate internal avenues are, and indeed what protections, particularly around protected disclosures, are available. I also like to be clear with people to say, look, if you go outside of these channels, then you're going to lose these protections. So, if you go to social media, if you go to regular media, you lose the protections if you're reporting serious wrongdoing that are available to you under legislation. You make yourself sort of you could make yourself fair game for I don't know what could happen there. So being clear around those particular aspects is going to be important. But yeah, I think having that information out there and making your expectations clear is going to be important.
Yep, I think it's going to be an increasingly problematic for organisations in dealing with that. I've certainly seen it in my work. So what I've just offered or suggested in the text is for anyone to throw any questions at us. So I'll just ask people. Please do feel free to throw a question across. But in the event that we don't get any questions, because you've covered it off brilliantly, what else, if you dip into your wisdom, would you want to impart on our guests today and those who may look at it online in the coming days, weeks, months?
Yeah, look, I think it's I probably just reiterate the messages I've already given, which are don't wait for this stuff to arise and end up on your plate and be left playing catch up. It's these much like privacy and protected disclosures. I think they don't appear to be exciting and wonderful and entertaining. They appear more like compliance factors, and they probably are as a way to think about them. But you don't want to. The first that you get involved in these issues is not fighting some sort of crisis on the back foot. Having in place a good framework, the right sort of policies, and someone within the organisation who knows what to do with this stuff, or at least can plug in quickly to their networks to find out what to do, is just absolutely key. Having, keeping your policies, your processes up to date, make sure they work for you. If you're buying off the shelf sort of policies and procedures, make sure they actually, meet your requirements and needs. But yeah, having someone who's got an eye on this stuff and is a voice for it within your organisation is always going to be key. I think that's the key advice I'd give to people.
Very, very sound and totally agree. That draws us to a conclusion. We haven't got any questions come through, but if anyone needed to get hold of you afterwards, Blair, best way to contact you?
Yeah, look, just on our website, dundasstreet.co.nz, or I think you put my link on LinkedIn up on your page. So yeah, you can get hold me through that way too. Yeah.
Great. Well, just briefly before we close out, so coming up over the next 3 days, tomorrow we'll be hearing from a business owner who collects large quantities of financial data of New Zealand organisations and interrogates that for fraud, abuse and waste. So tune in to listen to Wayne and I talk tomorrow. I'm then talking to an owner of a New Zealand headquartered but global security company on Thursday, Jonathan. And then on Friday, we're going to round it out hearing it from Neil, who is the founding partner of a public relations and crisis management firm. So in case anyone here today would like to listen in on that, please do register if you haven't already. To all the participants today, thank you very much. Really appreciate your time. Hopefully you enjoyed the discussion. Blair, as always, thank you very, very much. Always a good chat with you. First time we've done it over a webinar and recorded it, but why not share that knowledge around our wider community as well. So look, really, really appreciate your time. Thank you.
No worries. Thank you.
And have a great day, everyone.